I'm sure you've heard the great news. Mahmoud Khalil is finally free. And as we said in our very first episode, the students, Rumeysa Öztürk, Mohsen Makdawi, Yunso Chung, and others, they are winning. Khalil's freedom took the longest, 104 days. Without a doubt, he has become the face of a First Amendment movement during these early days of Trump's second term. And he is using his freedom to do exactly what the government went after him for, to speak out for Palestinian lives and an end to the war in Gaza. You're listening to The Bully's Pulpit, Trump versus the First Amendment. And today's show is a special one because we're going to be zeroing in on what's at the heart of Mahmoud Khalil's successive court victories and ultimately his freedom. The freedom of all to speak out without fear of retaliation. For non-citizens who are here in the US, no matter their immigration status. This very obviously includes the fear they'll be abducted off the street and taken to an immigration prison to be processed for deportation. This week, we'll talk about a big case defending this principle, a lawsuit challenging the administration's policy of arresting, detaining, and marking for deportation non-citizen students and faculty who engage in pro-Palestinian speech. If the government can violate First Amendment rights protecting that speech, it can violate the protections for any kind of speech.
There's really just no question that what Secretary Rubio is trying to do is tamp down on constitutionally protected speech he doesn't like.
That was Alex Abdo of the Net Institute, and I can't wait to wonk out on all of this with him, but also to learn more about the real-world harms these unlawful actions have. But before we do, let's get to the news. And you guessed it, Mahmoud Khalil kicks us off. Since its release, Khalil has been on a big press tour, speaking with the New York Times, NPR, and ABC News. And at a rally on the steps of the Cathedral of St. John the Divine, he gave a huge shout out to other students at Columbia University and elsewhere who are standing alongside him and calling for an end to the war in Gaza.
I would like to salute the courage of all students at Columbia and across the nation. These students who continue to protest, I want to honor especially my friends at Columbia University. Especially those who are currently battling expulsion and suspension for their consciousness stand.
A quick update on the LA protests. ICE continues to terrorize immigrant workers and day laborers, a topic of last week's show. I encourage you to go back and listen to the episode. It was great. Communities continue to resist and denounce these tactics. To this end, a new bill introduced in the State House in California would prohibit ICE agents from wearing masks during their enforcement operations. It would also require them to identify themselves. The California bill is called the No Secret Police Act. In other news, Media Matters for America, a liberal watchdog that keeps a close eye on right-wing extremism in the news and elsewhere, has sued the Federal Trade Commission in Washington over what it says is a retaliatory investigation of its work watching X, formerly known as Twitter. This is a big First Amendment problem we've been seeing during Trump 2.0, where the administration is launching investigations of news organizations and other entities. Media Matters has been in a legal battle with X in federal court for quite some time, all because X was unhappy that Media Matters reported a couple of years ago that ads on the platform were appearing next to anti-Semitic content. Now, the FTC wants to look into Media Matters as well, but Media Matters is fighting back. To quote the lawsuit, the agency is using its, quote, sweeping governmental powers to attempt to silence and harass an organization for daring to speak the truth. And in a surprising about-face, CBS blasted Trump's lawsuit against the broadcaster over a Kamala Harris interview as meritless. The network called the interview and the way 60 Minutes handled it as, quote, fully protected editorial speech. All of this suggests that maybe CBS wants to do the right thing. The backstory is long and complicated, so check out episode 5 with FCC Commissioner Ana Gomez if you'd like to learn more. Lastly, Trump's war on unions. As we've seen since the start of the Trump administration, the federal government is decimating the federal workforce. There's no better way to do that than by weakening their labor protections under federal law. Of course, organized labor, even that of federal workers, is protected by the First Amendment. And on this point, a federal judge in San Francisco ruled that Trump cannot end union bargaining rights for broad segments of the federal workforce. In his ruling, the judge pointed to the administration's open season on unions, noting that he has, quote, expressed a clear point of view that is hostile to federal labor unions and their First Amendment activities. We will keep tabs on how this court battle plays out on appeal. As we just heard in the news roundup, one student's freedom and his regained freedom to speak publicly about what he believes was the biggest thing happening in First Amendment land. Now that Mahmoud Khalil is finally free, it's as good a time as any to get deep in the weeds about one of the defining First Amendment issues of the second Trump presidency: the targeting of students and faculty who advocate for an end to the war in Gaza. Those who call what's happening there a genocide. People who deeply believe in Palestinian lives and freedom and are now seeing themselves abducted by ICE, taken to faraway detention centers, and expecting to be deported. They haven't been accused of a crime. Their only offense is what they believe, what they stand for. Not getting locked up for your views is precisely why the First Amendment exists. And to talk about this in an important case that gets to the heart of this issue, I'd love to welcome Alex Abdo. He's the litigation director at the Knight First Amendment Institute at Columbia University. Alex, thank you for coming on the show.
Thanks for having me, Christian.
Now, this case that you're about to go to trial, I want you to tell me about the plaintiffs in the case. Who are they and why they brought this lawsuit?
So we represent the American Association of University Professors. We represent several of its chapters at the universities of Rutgers, NYU, and Harvard. And we also represent the Middle East Studies Association. These are all faculty membership groups, and they exist essentially to defend academic freedom, to make sure that scholars are free to engage in the research and scholarship and debate and exchange of ideas that is central to academic freedom and the pursuit of knowledge in this country.
One thing that struck me as I was reading some of the filings in this case as a journalist, I was wondering, the universities, the institutions themselves should be bringing these claims on behalf of their students and scholars. But that's not what's happening here. And I want you to reflect on that a little bit.
Yeah, it's a real shame. You would think that in the midst of, maybe the most significant attacks we've ever seen in this country on higher education, you would think that the institutions of higher education would be leading the charge in response. And we've now finally seen, Harvard fight back against, the funding cuts that have presented an existential threat to the university. But we haven't seen a coordinated response. And I think that would be essential because the administration's strategy is one of divide and conquer. And we've seen this not just in this industry, but in others that the administration has attacked. It goes after one law firm, one university, one entity, and it steadily increases the pressure to an unbearable point until that university or law firm folds, and then it moves on to the next one. And I think the best response to that kind of divide and conquer strategy is coordination. It would be great if the universities banded together, presented a unified front, and pushed back. Unfortunately, that's not what we've seen.
Collective action, in other words. And collective action is precisely what I see when I read the filings in this case. AAUP v. Rubio, as this important First Amendment challenge is known. Now, what this case seeks is to invalidate the government's policy of arresting, imprisoning, and deporting students and faculty who express pro-Palestinian views. I believe you call this a, quote, ideological deportation policy. I'm curious, is this a written policy or is it something else?
Well, that's what we're engaged in discovery right now to figure out, is just to what extent the government has memorialized this policy in any number of internal documents. I can't actually go into the details of what we've been finding through discovery, but I can tell you what we alleged when we went into court, which is that, this is a policy that the government has announced from the Hills. Its senior administration officials have consistently explained that it is their view that if an international student or scholar expresses a view essentially that is pro-Palestinian, one that the government views to be anti-Semitic or anti-Israel, that they have the power to kick them out of the country. And that's what we have seen the administration do time and time again. And, we don't actually know the full sweep of the government's enforcement of this policy, but Secretary Rubio at one point seemed to suggest that it had been at least 300, students and scholars who they have revoked the visas of or taken some other immigration action against.
And that's one thing that, as a journalist, always strikes me when there is a legal policy, either written or unwritten, and it needs to come out later. And then there's like the public actions, what they announce from the rooftops or from the hilltops. And there's almost this disconnect because on the one hand, you're trying to defend this thing on legal grounds. But then publicly, the administration is putting out these smoking guns, as they say, basically telling the whole world, we're doing this for this reason. Now, why do your clients contend that this policy of targeting them for deportation, for pro-Palestinian views, is so harmful?
Well, it affects the ability of, our clients to do their work. And it does that in a variety of ways. Most directly, these faculty membership groups have a lot of international students and faculty who are members. These are people who are directly chilled by this policy because perhaps their research focuses on the Middle East, or they want to attend protests or engage in classroom discussions about controversial topics, including, of course, Israel and Palestine. Those are all legitimate forms of protected speech. But these individuals, now I think rightfully fear that the government will point to that kind of constitutionally protected speech as a basis for deporting them or as a basis for revoking their visas. So that's, perhaps the most direct effect, the international members of these groups. But the policy has a much broader effect, and that's in part why we wanted to sue it on behalf of groups like the AAUP and MESA, the Middle East Studies Association. And that effect is to deny the U.S. citizen members of these groups the ability to engage with their international colleagues, to engage in the kind of exchange of ideas that is supposed to be a hallmark of this country. And, it's trite to say as somebody who is a First Amendment litigator, but the First Amendment is one of the things that makes this country special. One of the things that distinguishes this country from other countries, and especially from autocracies around the world, is that you're supposed to be able to be free to say what you want, so long as it is legitimate political speech, without fear that mass government agents are going to pick you off the street and throw you in jail. And that's exactly what we're seeing right now. And it's shocking.
I have a friend who is from Iraq who has been living here for a few years, and I showed him the video of Rumeysa Öztürk getting picked up off the street. And he texted back and said, Cristian, I cannot believe what you just showed me. This is not something I ever thought I would see in this country, maybe in my country, but not here. So it's definitely a completely new normal or abnormal, so to speak. Now, I want to drill down on something you just said, Alex, and especially the reality that there are U.S. citizens who want to partner or who want to work with these international students and scholars. I could totally imagine a scenario where someone who belongs to one of these member organizations wants to write a paper with an American scholar, and the American scholar reaches out and says, hey, look, how about we partner to write this paper together? And they say, oh, no, I can't write that because if I put my name to it, who knows what's going to happen to me and my scholarship? Am I kind of onto something there?
Yeah, and that's exactly what we're seeing. We've talked to international students and faculty from around the country, and they are terrified. They are stepping back from public life. They are no longer engaging in debate on controversial issues, especially Israel and Palestine, because they are worried that somebody will notice that they're speaking on the topic. They'll send their paper, their syllabus, their tweet, a photo of them attending a protest. They'll send it to the State Department, and the State Department will deport them or try to deport them. And that fear is palpable, and it has created this atmosphere of repression on campuses around the country. And it really is hard to overstate how significant that effect has been for international students and scholars, and for international faculty. They have students whose classes are now being affected. Maybe you're only concerned about U.S. citizens. I don't think you should be, but maybe you are. And it's having a real effect for them too, for their ability to engage with interesting and important ideas that come from around the world.
Indeed. Now, this case, AAUP v. Rubio, it reminds me a little bit of the case of Mahmoud Khalil, who was just released from detention a few days ago. His case also challenges this so-called policy that you guys are trying to get at and invalidate. Now, how is this case that you're litigating different from Mahmoud's or other students who are also challenging their deportations?
There are really two main differences. The first is that, we are really focused on challenging the policy as a whole and getting relief against the policy as a whole. Our goal is to end the administration's broad efforts to target students and faculty on the basis of their pro-Palestinian expression. The second main difference is that we're trying to highlight, both for the public and for the courts, the broad effect that this policy has, not just on the individuals being targeted, but on the community of scholars and on higher education as a whole. And that's why we're suing on behalf, again, of these, faculty membership organizations whose mission is to protect academic freedom.
These plaintiffs are, in essence, standing up for student and faculty members' First Amendment rights as non-citizens. That's something the Supreme Court has said. Non-citizens have a First Amendment right to be able to speak without fear that they'll be deported based on their speech. But they're also standing up for themselves, these plaintiffs, as organizations whose own speech rights are being violated. Do I have that right?
Yeah, that's exactly right. These organizations rely on their membership to figure out what their priorities should be, to engage in the kind of advocacy that they engage in support of higher education and free speech and scholarship. But they've been impacted in their ability to do so because non-citizen members have stepped back from leadership roles. They've stopped attending meetings. When they do attend meetings, they stay on mute or they keep their videos off. Again, the chill is real, and it is hard to overstate just how terrified so many people are that they're going to be swept up in the administration's immigration sweeps.
Alex, we're going to get a little wonky here, so please bear with me. But at the heart of this case is a determination by the Secretary of State, as spelled out in federal law, that these students pose a threat to the foreign policy objectives of the U.S. government. Now, personally, to me, that's laughable on its face. I believe some of the students have also found it laughable. But something that's not laughable to me is that these cabinet-level determinations tend to be very, very difficult to challenge in court. We saw this with the first Muslim ban case during the first Trump administration. Whenever you have this clash between a First Amendment right and these national security prerogatives, a lot of times the national security side is going to win. Now, how should people think about this tension between the First Amendment and the so-called foreign policy objectives of the government?
Well, I think the most important thing to point out is that this foreign policy justification is an obvious fig leaf. It's a pretext. There's really just no question that what Secretary Rubio is trying to do is tamp down on constitutionally protected speech he doesn't like. And if that provides a basis for kicking people out of the country, that's just another way of saying that international students and faculty who are here lawfully have no free speech rights. And, maybe I'll accept the invitation to get wonky. But the Supreme Court has rejected that position. In a case about 80 years ago called Bridges, the Supreme Court made clear that non-citizens who are in the country lawfully have First Amendment rights. And if the First Amendment means anything, again, it has to mean that you can't be picked up and thrown in jail or thrown out of the country for engaging in core political speech. Now, to be fair, there are some legitimate questions about, what the full scope is of First Amendment rights that non-citizens have. There are some contexts in which those rights can probably be limited. Non-citizens can't vote, for example, even though the vote is perhaps one of the most potent, forms of political expression. But there's really, shouldn't be any debate that non-citizens have the core First Amendment right to engage in peaceful political protest.
And by the way, the case Alex just mentioned, Bridges, it's Bridges v. Wixon, decided in 1945, actually came up in last week's episode. Check that out. It was a great show. The case you filed it in March, and it's going to trial on July 7th. Now, to me, that's lightning fast as far as these things go. How come things have moved so quickly?
It is lightning fast. We filed the case, and a week later, we filed a preliminary injunction motion, which is basically a motion asking the court to put things on hold while the case plays out. And we asked the court to do that because the policy is imposing harms right now and is causing the kinds of harms that courts call irreparable. There's no meaningful relief you can get after the fact for the government having censored protected speech. But the court decided, better to move quickly to trial, and we have taken Judge Young up on that invitation, and we are, doing our best to race through discovery so that we're ready to go starting July 7th.
That would be Judge William Young of the District of Massachusetts, who, by the way, is one of my favorite judges, not because of the way he rules, but because he makes his courtroom publicly available through Zoom streaming, which not all judges do. So that's a big First Amendment props to him for making his courtroom available to the public, and people may be able to check out this trial as well that way. Now, naturally, because of this expedited nature, you've had to do a lot of work in a very compressed timeline. A few weeks ago, you won an important pretrial order preventing retaliation against witnesses. Can you tell me more about that order and why it matters so much?
Yeah, the non-citizen members of AAUP and MESA, who we've been talking to about potentially testifying at trial, they're scared. They're scared that if they participate in the case, if they present the evidence that they have to the court, that the government will retaliate against them. And so we asked the court to issue, we asked the government first to agree with us in a filing that it wasn't going to retaliate against these individuals and to limit the way it could use the information it learns about these individuals at trial. And the government refused. And that in itself was shocking and scary. And so we presented the motion to the court. The government opposed it, and the court very quickly ruled in our favor, issuing a one-sentence, very stern prohibition on any retaliation against people who present evidence at the trial.
If anyone wants to look up what's currently public, just the declarations from your clients expressing or explaining the harms that they face as part of this policy are very compelling. And I encourage everyone to look them up because from there, you're going to learn a lot about what the plaintiffs are facing in the flesh, like in real life. Now, for people interested...
Can I just underscore that, Cristian?
Sure, go ahead.
These people are heroes. These people have extraordinary courage, and I have been moved, to tears in some instances to hear their stories and to witness their courage and being willing to take the stand. And, it is really a heroic act and, one that somebody has to do, but it's very hard to be the one to make the decision to do it. And their stories, when they take the stand and in a couple of weeks, will be extremely, extremely powerful.
And we'll all be tuning in. Now, for people interested precisely in doing that and kind of tuning in, perhaps via Zoom or showing up in court or supporting the plaintiffs in this case, what should they be looking out for as they witness or read about the trial as it unfolds?
Well, the key question, the one that the judge has made clear he wants to hear evidence on, is whether this policy in fact exists. And so, we're going to present evidence that this policy does exist, that administration officials have been talking about it, and they've been taking a lot of steps behind closed doors to implement it. That will be probably the central factual question in the case. The other one that Judge Young said he wanted to hear about is whether our clients have been injured, whether they have what is called legal standing to be the ones going into court to make these claims. And so, as I mentioned, we'll be presenting some of the non-citizen members, some of the citizen members of our clients on the stand to testify about the harms that this policy has caused them.
And finally, Alex, the summer is usually an opportunity for everyone, even lawyers, to recharge and to rejuvenate. But I imagine this summer, which is only getting started, feels a little different. As I said, Mahmoud Khalil has finally been released, but the Trump administration is charging ahead and with attempts to deport him and other students and faculty members targeted over their pro-Palestinian views. What would you say to people in your orbit tempted to give in to despair? How do you encourage yourself, your team, and all the amazing lawyers taking on this work?
You have to be an optimist. You have to have hope that with enough fight, enough backbone, enough courage, we can push back. And that's what has kept me going personally in this line of work for the past 20 years or so. And that's what I have drawn hope from when I look at the people who have done this work in the past, who I idolize, who are my models. You have to have hope. You have to have fight.
Alex, because you just piqued my curiosity, who are some of those idols that you look up to?
One of the ones I like and I look up to is Aryeh Nair, somebody who has had decades of public service in human rights, who, even though he's been doing this for so long, still to this day is so committed to these foundational principles and unflinching in identifying what he thinks of as wrongs and calling them out.
Alex Abdo, he is the litigation director at the Knight First Amendment Institute, and he will be there at the trial in AUP v. Rubio. Alex, thank you so much for coming on the show.
Thanks again for having me, Cristian.
Good luck to all the lawyers who have been working around the clock to be ready for trial on July 7th. And if you're in the Boston area, please come out to the federal courthouse, where there will be a rally in support of the plaintiffs and all the students and faculty who are fighting for their right to speak out without fear. Before we end our show, I want to make a quick clarification regarding a point made in last week's episode. I said that a 2011 Ninth Circuit decision establishing a First Amendment right for day laborers to seek work in public also established the law for the entire nation. Instead, the case set binding precedent in the Ninth Circuit, and that precedent became persuasive authority for other courts throughout the nation. See you next week. The Bully's Pulpit is a production of the Knight First Amendment Institute at Columbia University. I'm your host, Cristian Farias. This episode was written by me and co-produced by Anne-Maria Watt and Candace White. Our associate producer for this episode is Kushal Dev. Fact-checking by Kushal Dev, Ellie Fivas, and Ella Sohn. Our sound engineer is Patrick McNamee. Candace White is our executive producer. Our music comes from Epidemic Sound. The art for our show was designed by Astrid De Silva. Thanks to Alex Abdo, who joined us for this episode. The Bully's Pulpit is available on Apple, Spotify, and wherever you listen to podcasts. Please subscribe and leave a review. We'd love to know what you think. To learn more about the Knight Institute, visit our website, knightcolumbia.org. That's Knight with a K. And follow us on social media.